Thanks for joining me on another edition of Handy Law. We are still on Nigeria's Administration of Criminal Justice Act 2015. Today we will look at the provisions of the Act regarding probation. Probation is a sentence in which a person found guilty of an offense is retained outside prison under the supervision of a probation officer. It allows the person to remain within the community instead of going to prison. It also requires that the person complies with certain court-ordered rules and conditions. Whether the probation continues or ceases is dependent on the offender's ability to keep to the rules in the probation order. Where a defendant is charged before a court with an offense punishable by law, and the court thinks the charge has been proved, but is of the opinion that due to some factors like the defendant's character, his age, his health, his mental condition, or due to the fact that the offense is trivial in nature, or some extenuating circumstances under which the offense was committed, that it will not be necessary to inflict punishment other than a nominal one on the defendant. And if the court thinks that it's expedient to release the defendant on probation, the judge may, without proceeding to conviction, make an order either releasing the defendant or releasing him conditionally upon his entering into an agreement to be of good behavior and to appear at any time during the period not exceeding 3 years that may be specified in the order. The court may also order the defendant to pay damages for investigation or compensation for any loss suffered by a person by reason of the conduct or omission of the defendant. Where the defendant is less than 18 years old, the court shall order the parent or guardian to pay damages or costs, especially if, in the opinion of the court, the parent or guardian gave tacit approval to the commission of the offense. An agreement ordered to be entered into shall contain a condition that the probationer must be under the supervision of a probation officer of the same sex. The agreement may also contain additional conditions like the residence. That is, the probationer may be required to remain in a structured living environment for some time before moving back into the community. Abstention from intoxicating substances, and any other thing that the court may, having regard to the circumstances of the case, regard as necessary to prevent repetition of commission of other offenses. Where the person on probation is not actually with the probation officer, the probation officer may, subject to the direction of the court, visit or receive reports at reasonable intervals about the person, ensures that the probationer keeps to the conditions of his undertaking, reports his observations to the court, advises, assists, befriends the probationer, and when necessary, helps him to find suitable employment. The court may vary the terms and conditions of the probation at the recommendation of the probation officer. The probationer will be invited to court to show cause why the terms and conditions of the probation should or should not be varied. Variation could be to extend the time of probation or to reduce it, but it must not exceed 3 years from the time of the original order. Variation could also alter the terms or add additional terms to the probation agreement. At the application of the probation officer, the court may discharge the probationer from further supervision. But if the probationer fails to observe the terms and conditions of his probation order, he may be arrested and the court, without needing to prove further guilt, convict and sentence him for the original offense. Hope you found this instructive. Please like, share, and subscribe.